We're going to go ahead and get started through some of those housekeeping slides. First thing is this lecture is one of our live lectures, therefore it is rated E for all levels of care and everyone. So all the way from the EMR level up to the paramedic level. Today, Mr. Givet is going to be talking about some generic medical, legal, and ethical considerations. So not a whole lot of protocol-based stuff when it comes to individual levels of care. But as always, it is aimed at all levels of EMS providers. Our disclaimer, especially with specific patient care topics, please make sure you follow your local protocols. As well as today's topic, make sure you consult your emergency room physicians, your medical directors, your training folks to make sure that you are following correct protocols and procedures. We have an AI disclaimer required by our CAPC accreditation that just says we may have used AI-generated images or AI-generated closed captions during this video. So that is your disclaimer for that. As always, I'm your host, Sean Pitts. I am the head of education here at EMS Connect, host of the EMS Connect On Shift podcast. I am a Lieutenant Firefighter Advanced EMT here in Spokane County. Joining me is David Givet. David, would you like to give your introduction here, sir?
I became a paramedic in 1987, or an EMT in 87, paramedic in 89. Around the turn of the century, took over operations of the largest commercial ambulance company in the state of Maryland at the time. Worked my way through that, got them turned around, found a lovely young lady, got married, had a kid, moved back to California, went to law school, and now I am a criminal and EMS defense lawyer, meaning that when EMTs and paramedics and nurses in California find themselves facing license discipline, I'm the guy they call to try to make sure that that does not work out, that they keep their license, that they stay protected. That is who I am. And that is why every class I teach, everything I do comes from one place, and that is to keep providers safe. That's my only goal in life right now.
I love it. And a hockey fan, which finally I get a guy who enjoys hockey as much as me. So I appreciate that.
Those are my Coachella Valley Firebirds, baby. Go Birds.
All right. Well, I turn this over to you, sir. I'm looking forward. We'll go a little bit and then I'll throw some of these questions at you.
Okay, rock and roll. You didn't pimp out my book, but I'll do that anyway. I am also the proud to say the Amazon best-selling author of Sirens Licensed Lawyers, the law and other really important stuff EMS providers never learned in school. You're going to get a good chunk of that today. So if you happen to purchase the book after this session today, whatever you read, you're going to read in my voice and you'll hear my voice saying it. And that's going to be a lot of fun for you. And if you buy it off Amazon, I'll get my $1.25. Here's the thing, boys and girls. The name of the presentation today is Keep Calm and CYA. We all know what that stands for. But really, really more than that, we are going to spend the next couple of hours planting seeds. I'm going to throw a lot of material at you, a lot of information at you. And as I said in the beginning, the entire purpose of everything we talk about today is going to be to keep you safe, to give you the fundamental, basic information you need to stay safe as a provider. Understanding that the collateral benefit, the natural collateral consequence of you being as legally safe as you can possibly be is that your patients and the community as a whole can only get the best possible service, because that's the only way you can be safe, the best possible care, because that's the only way that you can be safe. Now, a lot of the stuff that I talk about today, some of it is going to connect right away. It's going to hit you right in the front of the brain. You're like, oh, I get that, or I had that experience, or I was on that call. That makes sense, and it's going to register. Other stuff that I talk about today, you're going to be like, what did he say? I have no clue what those words even mean. But you do. And you'll feel like it's going over your head or in one ear and out the other, but that's not what's happening. I promise you, we are planting seeds, and a month from now, or 6 months from now, or a year from now, you're going to find yourself in a situation, or someone's going to ask you a question, or something's going to happen, and just like that, out of nowhere, you're going to have the exact right response and have no clue where it came from. It came from the foundation we are laying today. As we go through, you're going to have questions. There's going to be a time when I answer those questions, so be sure to get them all in, and I'll spend as much time as you need answering them. The last little bit before we really dig into it is this program, this particular program is sort of built on a progression, meaning We're going to lay a real easy foundation, and then we're going to build on it. We're going to build on that and build on that. And everything we talk about is going to be kind of built on the thing we just talked about before, so that everything we talk about today has context. All right. So here we go. The most basic, the most fundamental, not just legal principle, but life principle anybody can learn is this. You can't throw your bottle on the floor and cry because you don't have it. Came to me about, I don't know, 22 years ago or so. My daughter's about 2 years old, and she went through that phase where, if you got kids, they go through that phase, they have their bottle or their toy or their whatever, and they chuck it on the ground, and you got to pick it up and give it back to them before they start crying. That's the game. Well, one day my wife and I are driving down the street. She was driving, I was in the passenger seat, and our girl's in the back seat, all strapped in and drinking her apple juice out of a bottle. And I saw it at the corner of my eye. She just chucked that thing on the floor, man. It didn't slip, it didn't fall. That thing it was a malicious act on her part. She chucked that thing on the floor. And then of course she's gonna reach it, so she kind of whimpered a little bit and kind of started to cry a little bit. And my wife, she says, "Hey, honey," she dropped her bottle, pick it up. And I said, "No." My wife said, "What the blank are you talking about?" I said, "Honey, look, she's almost 2 years old, and in this life, that's old enough to know you can't throw your bottle on the floor and cry because you don't have it." And I swear to God, the best person I know, my best friend in the world, if there's such a thing as soulmates, she absolutely is one. She paused for a second and she's kind of thought about it, and she said, she nodded, she goes, "Yep, I get it." And we never did pick it up again. And she cried her way through it. And that became the lesson of her life. You can't throw your bottle on the floor and cry because you don't have it. Meaning, you can't know the rules and break them and be mad or surprised when there's a consequence. For her, it was, you can't know there's a test coming up, or report cards coming out or whatever, a volleyball game coming, and not study or do your homework or practice, and then be upset when you get a bad grade or lose the game. And that I offer to you is this: you can't know your policies and protocols and procedures and training. You can't know those things, violate them in any way, and then be surprised, much less upset, when there's a consequence. And I can assure you, no matter where you are, there will be a consequence, whether it's administrative from your agency, or worse, administrative from your licensing agency, the board, the state, the county, whoever regulates your ability to practice. I can assure you, when you violate your policy, protocol, and procedure, they're not going to be amused, and there's going to be a consequence. With that in mind, we need to attack, it's my position that you need to attack the subject of the law as it relates to EMS with a very careful understanding that in this job, unlike I think any other in the world, the mindset one has going into every shift or every call is absolutely everything. And likewise, EMS providers, unlike anybody else in any other endeavor I can think of, EMS providers have a very different, a very specific mindset. I include even though I'm a lawyer now, as a paramedic for many years, this, it's my first love. I include myself in everything I talk about. When I say EMS providers this and EMS providers that, I'm talking about myself as well. So when I say that, EMS providers have a different mindset than anybody else in society. Every one of us, everyone, without exception, came to EMS with the mindset of helping people. Man, we were gonna save the galaxy. We were going to be Luke Skywalker, right? We were gonna get out there and do good for the universe, right? We were gonna be the ones you call on your worst day, in your worst possible moment. We're the ones you call. Call me, I'm gonna come help you. I don't care what you look like, or who you sleep with, or how much money you have, or who you voted for, or I don't care. It doesn't matter who you pray to. Doesn't matter. You're in trouble, you call me, I'm gonna come get you, because gosh darn it, I wanna help people. And then about 5 minutes, maybe for some of us 10 minutes in, we realize, oh man, I hate people. People suck. People are the worst. And then we realize we spend entire careers going from this guy to this guy. Some days we come back from, like a 4-day from the lake or the river, the beach or the slopes or wherever you go to unwind. You're feeling good. You run a couple calls, about that third or fourth call, like, oh, that's right, I forgot. I don't like you people. Understand that that is perfectly normal. That is how EMS providers, I think, ultimately are intended to function. We bounce, right? But we have to understand that the law doesn't care what mood we're in. The rules, the policies, the protocols, the procedures, the training, the law doesn't care whether we are feeling like the good guy or the angry bad guy, whether we're feeling ready to rock and roll or whether we burned out. The law doesn't care. The law is the constant. It doesn't waver. It doesn't judge. It doesn't pick sides. You either are within it or you're not. And that is fundamental to understand, that it only functions in one of two ways. The law is only ever the sword or the shield, meaning the exact same law, the same rules, the same ink on the same paper, the same policies and protocols and procedures, the same everything functions initially as a shield. If you stay within it, if you comply with it, if you do what you're supposed to do the way you're supposed to do it, the law will absolutely be your shield. It will protect you and make sure no matter how bad somebody says something is, it will be the thing that protects you from bad things actually happening. However, if you decide, this time I'm gonna do it my way, or I'm gonna function outside policy and protocol and procedure, I'm gonna violate just a little bit because it's convenient, whatever it is, then the very same rules, the very same law, the very same ink on paper that 2 seconds ago was your shield will become the sword that metaphorically kills you and effectively takes away your ability to practice and therefore your career and therefore all of your stuff. It's the same rules and they apply equally to everybody. Let's look back and remember how laws are created, right? You've got legislatively, the first and foremost way laws in our society are created. Remember, I'm just a bill on Capitol Hill. Remember that? The legislature gets together and they decide this is going to be the rules. This speed limit is 70, or you got to be 21 to buy alcohol, whatever it is. They get them down, they write them, the governor signs them, the president signs them, and them's are the rules, right? The stereo instructions of life. We have to follow them. If we do, we're good. If we don't, then we got problems, right? Very simple, very straightforward. But it's not the only way that laws affect us as EMS providers, affect you as EMS providers. Administrative law, meaning the policies and the protocols and the procedures and all the things that you studied and you took the test and you got your license and you get to go practice now. We are taught, I was taught, you were taught, that those are the rules, right? Those are the policies. And if you break them, you broke a rule, you violated a policy. But what nobody told us, what I'm telling you now, is that those policies, those rules, those protocols and procedures are all actually incorporated by reference into the law. In California here, it's the Health and Safety Code. Where you are, it might be something else, but it's there. So when you violate policy and protocol or procedure, when you violate the rules, you're actually breaking the law, and you can and likely will be prosecuted in whatever measure is appropriate. Generally, it's administrative, but it could be worse, okay? The third way laws, I'm not gonna say laws are creative, but the third way laws affect us, our lives, our daily lives, are through what's called cases and controversies. So-and-so versus such and such. Case law, legal precedent. We've heard it any number of different ways, but so-and-so versus such and such, right? One side fights another side in court, one side wins, the other side loses. The losing side gets mad, they take it up on appeal to the appeals court or the Supreme Court, and the appeals court or the Supreme Court renders a ruling. They draft a decision and an opinion, and that decision and that opinion become the law of the land as it relates to that very specific area. For example, if I say, what is the most famous, the most popular case, so-and-so versus such and such, that you've ever heard of, each of you right now is probably thinking Roe versus Wade. And if I were to ask any of you right now, what is Roe versus Wade about, you would say Roe versus Wade was the case in 1973 or 2 or whatever it was that made abortion legal. Well, that's not what it was. That may have been what happened, but that's not what the case was about. The case was a very complex constitutional question. Was the right to that particular medical procedure included in the right to privacy that is inferred from the Constitution? That was the question. It was a privacy rights case. And so for the next 53 years, anytime there was a privacy rights issue before any court, one side or the other would use the Roe case as their legal precedent to either argue for or against whatever position they held. It didn't create law, it tailored and shaped how it worked. There are hundreds of thousands of those kinds of cases nationwide that affect our everyday life. There are two cases in particular that every EMS provider needs to know about. And these are California cases. And let me tell you how case law works. In whatever state the case is decided, in whatever state, assuming it's not a federal case, any state case, whenever a state case is decided by an appeals court, then whatever the subject of that case is becomes case law, so legal precedent. So the next time a similar issue comes up, we now know the shape of the rules, okay? If you're in a different state, if that state has a similar case on point, then the other state case doesn't matter. But if the state you're in doesn't have a case on point, then the case from out of state could be used as precedent in your state. So I'm going to talk about two California cases. And if there is a case on point where you are, all you got to do is change the name because the principle is going to be the same. If you don't, these are going to apply to you. The takeaway is that no matter where you are and whatever name of the case that governs, these two cases represent the rules that absolutely affect you. The first case is called Wright versus City of Los Angeles. Wright versus City of Los Angeles takes place, I think, in 1979. Mr. Wright is out in front of his home and he is in a physical altercation with another guy, just getting the ever-loving daylights beat out of him. Cops come, police come, and they arrest both guys. They take Mr. Wright into custody. When they take him into custody, he tells them, "I hurt all over, I need an ambulance." I said, okay. Call for an LA City Fire Department rescue, rolls up. Two paramedics on an ambulance. I don't know what the other guy does, but the one medic goes, he walks over to Mr. Wright. Now, mind you, Mr. Wright, South Central LA, beat up, sweaty, handcuffed, laying in the gutter. Medic walks up to him, kind of leans over, and he says, "Are you hurt?" All right, got to start your assessment somewhere. Why not there? Mr. Wright's answer was something to the effect of, "No, I'm okay. I just want a glass of water or a blanket," or some weird thing that didn't exactly fit the situation, but fair enough. The medic performs what he described as a 60-second visual-only assessment to confirm shock. Now, I'll wait a minute while you laugh that off, because if you've gone to EMT school, paramedic school, any level of EMS training, you know that a 60-second visual-only assessment to confirm shock doesn't exist. It's not a thing. It never was. It never will be. But he did it, and lo and behold, no shock. Police officer says, "Does he need to go to the hospital?" Medic tells him, "Well, police officer, in your police car, if you're going to take him to jail, you might want to swing him by the doctor first." Also not a thing. Takes out his pen and his clipboard. PD only, FD not needed, no patient. And they take off, out they go. Well, of course, Mr. Wright, about 15, 20, 25 minutes or so later, is entirely, completely, irretrievably dead. He died from sickle cell crisis. Family filed a wrongful death lawsuit. What the lawsuit said was, "Hey, our guy was there and he was sick or hurt and needed help, and your guy was there to help him, and your guy didn't help him, and our guy is dead, and it's your fault." And the city said something to the effect of, "It can't be our fault because we didn't do anything." Okay, fair enough. And believe it or not, they won. And the city takes it up on appeal, and the appeals court said, no. The appeals court said, and this is what you need to know, no matter what level of care you provide. The appeals court said that when this provider, and extrapolate, when you are approaching any patient in furtherance of the reason for which you were called, the provider-patient relationship right there and then is established. Court went on to say that relationship cannot be violated, meaning it cannot be terminated, meaning you can't separate from that patient unless and until you have done all of the things that policy and protocol and procedure require you to do. It could be transporting to the hospital, that could be effectuating an AMA, That could be executing whatever other kind of policy you might have or protocol you might have in your area, but you gotta do all of the things. What the court said was, these medics arrived, this particular medic arrived, he was approaching and commenced his assessment of the patient in furtherance of the reason for which he was called, the duty attached. When he turned around, didn't treat the patient, didn't do anything, didn't follow any policies, just basically pieced out, that constituted abandonment. So every call you go on, every call you've ever been on probably, as you approach the patient in furtherance of the reason for which you were called, your duty to that patient right there and then attached. Unless and until you've done all the things required, if you terminate that relationship prematurely, that constitutes abandonment. So I'll ask you, don't tell me. I'm going to ask you, how many times was today, Wednesday? How many times this week have you technically kind of abandoned a patient? It happens all the time. It shouldn't. Now, I want to say one more thing about the right case, and that is that I don't believe you necessarily even need to have eyes on the patient. Let's say you pull up to the house, it's an unknown medical, or it's a chest pain or something like that. You're walking up to the front door, you're getting ready to knock, the patient is inside, but you're approaching in furtherance of the reason for which you were called. I would argue that your duty to that patient, that relationship has already attached, okay? That is the right case. 10 years later, we get Zepeda versus City of Los Angeles. Mr. Zepeda, also a resident of beautiful South Central LA, he is out in front of his house and he is having a business disagreement with a colleague, let's say. And as many such disagreements are resolved in that area, he was shot in the neck, falls to the middle of the street, bleeding to death. They call 911. LA City Rescue rolls out. In fact, everybody, it's a shooting, everybody rolls out. But the first unit on scene is the paramedic ambulance. Before anybody else gets there, paramedic ambulance arrives. And of course, they stage. But did they? They kept their lights on and parked about 40 yards down the street on the same street where the patient was lying bleeding to death, about 40 yards down. So I wouldn't call that staging so much as, I don't know what I call that, but that's not staging. If you drive the apparatus, right, and you get called to a scene where you're supposed to stage, turn your lights off and park around the corner somewhere where they can't see you, okay? But there they were, lights on, 40 yards down, Zepeda's bleeding to death in the middle of the street. The bystanders are out there doing those bystander calisthenics, the jumping jacks, like see over here, like C-3PO in the desert, over here, like that. But it was the 80s, and for those of you old enough to remember, what we used to say back then was not gonna do it. And they waited, and they waited, and they waited, and the family or whoever it was comes running down, and they're banging on the ambulance windows. Hey, it's safe. The shooter's gone. He's dying. Don't let him die. Please, it's safe. The shooter's gone, but not gonna do it. And they waited, and they waited, and they waited, and they waited. PD finally rolls in. They clear the scene. Zepeda's dead, completely dead. 814, completely dead. Family files a wrongful death lawsuit. What did the lawsuit say? Well, it said, using right as its sword, according to Wright versus City of Los Angeles, the lawsuit said when they arrived on scene, their duty to the patient attached. By virtue of them not doing anything for the patient, letting them bleed to death, they breached that duty and the patient died and it's their fault and they won. And the city said, I don't think so. And the city took it up on appeal and the appeals court said, whoa, no. First thing the appeals court said was, right doesn't apply. This is not a right case. In Wright, they approached the patient. In Zepeda, they approached the scene. In Zepeda, the court said, they never initiated contact. They never approached the patient, or the operative legal language is, they never put Zepeda in a position where he was worse off than had they not responded at all. Now, their duty to the call, their duty to the scene most definitely attached, and they were there before anybody else, so they certainly complied with that, but they never put Zepeda in a position where he was worse off. They never approached him in furtherance of the reason for which they were called. So number one, the court said right doesn't apply. The second thing the court said was obviously they were following policy, right? Shooting, stabbing, violence of unknown origin, where the whereabouts of the perpetrator are unknown, unit shall stage, wait for PD to clear the scene. I do these classes in person all over the country. Everyone has the same policy, same basic policy. And that's what they did here. So number two, the court said, it's allergy season out here, don't mind me, it's not what you think. The second thing the court said was they were following policy. So right doesn't apply, and they were following policy. But the third thing the court said, and what I think is the most important thing the court said was, well, I got to do a little background. The court said, based on another case, so the court was relying on other legal precedent. The court said there was another case that tells us that police officers, cops, with guns and sticks and mustaches and all that stuff that cops have, police officers do not have an absolute duty to put themselves in a position where they reasonably believe they'll face grave danger. And no joke, I probably read that 3 or 4 or 5 times because I didn't get it. Because in my brain, I'm like, well, they've got guns, right? Grave danger is why we have them. But no, think of it like this. Think if I was a cop, and I could even grow a mustache, which I can't, right? And I'm in a room with all of you, and in one of the other rooms, there's a guy with a gun by himself threatening to kill everybody who comes into his room. It's not going to be my job as the only cop to go in and confront him. It's going to be my job as the only cop to protect you and to make sure you don't go in there, and to call the dogs and the SWAT teams and the helicopters and everybody else and make sure that we initiate the proper procedures to handle that, okay? What the court said was, if police officers don't have an absolute duty to put themselves in a position where they reasonably believe they'll face grave danger, then first responders don't, firefighters don't, EMTs, paramedics don't. And that in this case, effectively, it was perfectly reasonable to believe that if, that guy wanted that guy dead and this guy went in to make that guy not dead anymore, that guy was going to make this guy dead. What the court said was, right doesn't apply. They followed policy and they acted reasonably. Your takeaway is that on every call you go on, whether there's a patient or not, no matter what you do, in everything you do in furtherance of this job, if you do it reasonably, that the law will protect you. The law will remain as your shield. The Zepeda case will be your shield. Now, reasonableness for our purposes is basically defined this way. That conduct that a reasonably prudent, sober provider would do with the same level of training and experience in the same area under similar circumstances, okay? Legally, reasonably prudent, sober provider. I know you're not supposed to use the word in the definition, but they do. That's not I don't pave the roads, I just drive on them. That which a reasonably prudent, sober provider would do with the same level of training and experience in the same area under similar circumstances, okay? Now, keep in mind, a lot of people get caught up on in the same area, and they assume or they believe that it means that if we're in the same area and everybody does it in the same area, it must be okay. That's not what that means at all. For example, if everybody in your area employs the hand drop test to determine whether a patient is actually altered, that will never be considered reasonable because nobody's been trained on that technique since like 1977, right? And if you're doing it now, don't do it anymore because it's not going to be deemed reasonable, okay? All right, want to move on to 2 other cases. These are the Hackman case and the Schulman case. These are not legal precedent cases. These are not published cases. These are just 2 cases that I stumbled upon while I was doing research for the earliest versions of my documentation training, which you're going to get a lot of today, lucky you, that I talk about them because as an EMS defense lawyer, as someone who defends providers for problems they have, for things that happened on the job, these 2 cases represent the 2 most common issues that I have to deal with. The first one is the Hackman case. Hackman, very long story short, she's driving down the road, she hits a pole or a tree or something, and it causes a pretty significant indentation in the front of her car in the shape of the thing she struck. There's airbag deployment, there's windshield damage. The medics arrive on scene. She's got a little trickle of blood coming down from her forehead. She's unstable on her feet, and she appears to be a bit dazed. To their credit, the medics roll up and they were ready to do their thing, and they commence their assessment. Hey, how's it going? What's going on? Or what? I don't know what they said, but they start doing their thing. About a minute or so, or 2 minutes or less into the assessment, she tells them, guys, I'm fine. Leave me alone. I don't need your help. I don't need to be treated. I don't need to be seen. I got to deal with this. I'm fine. I'm not hurt. Just thanks, but no thanks. It happens all the time. Unfortunately, their response to that was, oh, okay, cool. Well, listen, sign this blank AMA and call us back if you need us. Okay. They didn't try to persuade her. They didn't do anything else. They just said, sign here, and then they peaced out. Of course, about 15 or 20 minutes later, she is completely unconscious. The same unit rolls out back to the scene. They see her, they pick her up. Okay, I don't know what they said, but it probably wasn't TV friendly. They pick her up, they take her to the hospital. I think she ends up being fine. But of course, she files a lawsuit. The lawsuit said, California suit. So lawsuit said, according to Wright versus City of Los Angeles, when they arrived on scene and commenced their assessment, their duty to her, the relationship attached, it was established. Of course it was. Under Zepeda versus, citing Zepeda as their sword, both cases as their sword, under Zepeda, they were not reasonable in the way they executed that refusal. They were not. So back again under Wright versus City of Los Angeles, when they left without having done what they were supposed to do, they abandoned her. Now the agency that employed these two paramedics, very, very aggressive lawyers, very good, strong, skilled, aggressive lawyers. And they looked at this case and they said, all right, how much? And they cut a check pretty quickly. What's the takeaway? The takeaway is don't do that. The bigger takeaway, the reason that I talk about this case, the thing that I encounter most, requires that we accept a few fundamental truths about ourselves. Remember before I told you, I'm talking about myself too. EMS providers, we are not like other people. We never have been, we never will be. Thankfully, my wife was a paramedic when we met, so we are and have always been on the same page. You'll understand what I mean when I tell you what I'm about to tell you. The first fundamental truth we have to accept about ourselves is that EMS providers, doesn't matter what level, we EMS providers are the least mature members of society. Hands down, there is no segment of society that is more immature than we are. Great, own it, love it. Farts will always be funny. It's great. But in the moment, on the call, when it's happening, got to be the grown-ups in the room to take control. If we don't have control, we don't have anything, which leads us to fundamental truth number 2. Everyone out there who isn't us is stupid. They don't know what they don't know. It is our responsibility. It is our job. It is our duty to know it for them. Got to be the grown-ups in the room. Got to understand that they don't know what they don't know, and we have to know it for them, which leads us to the third thing, and that is we cannot afford to react to what we see directly in front of us. Think about this. Every one of you, I think, no matter if this was a live audience, I would call on someone, but I know this is true of every single person watching or listening right now. Before you got into EMS, whatever it was you were doing in life, you're driving around, in your little car, just cruising down the road, got your stereo blast and doing your thing, paying very close attention to the car in front of you so you don't crash. I know for a fact that no EMS provider who's had any time in the field, who's watching this, we do not pay that much attention anymore to the car directly in front of us, because if that's where our attention is, it's going to be too late to react. Our attention now, just out of sheer training and habit and muscle memory, we are looking 3, 4, 5 cars ahead. We are looking, scanning the horizon, the rearview mirrors. We are attempting as best we can to look at all things at the same time. Because if something is going to happen, it's not going to start right here. If it does, great, we can react to it, but it's probably going to start somewhere down there. And if our attention is there and we can see it begin to develop, then we can avoid it. The same principle applies here. These guys, us, we, you, everybody, these guys needed to look at the mechanism of injury. They walk up on the scene and they needed to see the substantial indentation in the thing and the shape of the thing she struck. Windshield damage, airbag deployment, unsteady on her feet, appears dazed. They needed to tie all of those things together and recognize, yeah, I imagine you're feeling pretty good and pretty pumped up right now because you just crashed your car. And as a result, you probably have a whole truckload of adrenaline floating through your system. But how long does that last? 15, maybe 20 minutes? And when that wears off, based on what I see, I don't think you're going to be feeling so hot. In fact, based on what I see, I think you could be injured. So how about this? Let me finish checking you out. Let me finish examining you. Let me finish doing what I got to do. No purchase necessary, no obligation whatsoever, but let's make some decisions about what we do next after we know what we're dealing with. However you want to say it, doesn't matter. You could be charming, you could be however you want to be, okay? But you got to try, you got to let them know, understand that they don't know what they don't know, and they don't understand mechanism of injury, and they don't understand secondary, and they don't understand all these things that be going on. And you got to take control of the scene. That's what Hackman tells us. You have to take control of the scene and the situation and the patient and understand that you are in control. It is your scene. And if someone doesn't want to go to the hospital with you right now, great. I'm still going to try to do all of the things I need to do to, first of all, determine whether that's a good idea at all, and second, to determine what to do next about it, okay? That's what we learned from Hackman. That brings us to the Schulman case. The Schulman case represents probably the single biggest problem, the single biggest issue that I see affecting field providers who find themselves in pretty significant licensure trouble for something that happened on the job. Very long story short, Sarah Schulman is a 22-year-old college student at Pepperdine University in Malibu. If you don't know, Pepperdine is a very expensive, very exclusive, very private, if you know what I mean, university on the bluffs overlooking the Pacific Ocean in Malibu, California. Very specific clientele, shall we say. Sarah's out one night with a group of friends from school, and they're at a restaurant down in Malibu called Duke's. They are having dinner, they have some drinks, it's a great night. While they're there, Sarah only has one like pina colada or Mai Tai or some kind of frosty Polynesian Hawaiian thing they're known for. Great, has a great time. About 2 hours or so, they're there. Dinner's done, they pay the check. Sarah goes home. I believe the story goes she goes back to her apartment by school to change her clothes, and she meets up with the same group of friends at a bar on the north end of Malibu called the Doom Room, and they're there for karaoke. It's karaoke night. They all go in, they get a table, they order a round of drinks. She gets up, she sings her song, she comes back down, and out of nowhere, she develops an excruciating pain in her left ear. So she gets up kind of quietly. She kind of goes outside for 20, 30 minutes or so, wherever long she was out there, to kind of, you get like, what the heck's going on? And kind of figure it out. I don't know what she was doing out there for so long. While she was out there, though, the pain got worse and she became profoundly dizzy. So she goes back in toward the bar to tell her friends, hey, I'm not feeling so hot. I think I'm going to go lay down. Thanks for a fun night, whatever it was she was going to say. But she can't even do that because as she's walking back in toward the bar, the pain and the dizziness both get worse. She develops incomprehensible slurred speech and a staggered gait. What's wrong with her? All of you probably just thought it or said it. She's stroking out. She's having a stroke. Something upstairs ain't how it's supposed to be. Friends take her back outside. Now, mind you, we're like, half an hour or so into the event. Friends take her back outside and they're with her for like another 20 minutes, 30 minutes out there as they observe all of the symptoms get worse and worse and worse and worse until ultimately they describe she vomits really far, right? So we know it's been going on a while, and she collapses unconscious. They call 911. LA County Fire Department squad rolls out, 2 paramedics, dun, 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 Johnny and Roy, right? They arrive on scene and they hear the same story that I just told you. What they hear: drinking, slurred speech, staggered gait, vomiting, unconscious. What's wrong with her? She's drunk, and she's a spoiled, rich Pepperdine drunk, and we hate them. That's how they proceeded to run the call for like another 30 plus minutes on scene. So now the bystanders are bickering back and forth. She's not drunk, she's sick. Oh, she's drunk. We know what we're doing. They're just being typical judgmental. They assume they know what's going on, so they're acting on it. About 90 minutes into the event, about 30 minutes after they arrived on scene or so, they finally load her up and they take her to the hospital. Now, for those of you who may not be familiar with the area, the transport time, code 3, lights and sirens, from the top part of Malibu down to Santa Monica where the hospital is a good 20, 25 minutes maybe with no traffic. So by the time they get her to the ER, she's 2 hours almost into the event. What do they tell the nurse? She's drunk. Oh, put her in there, we'll get to her. And it's another, guess what, 30, 40 minutes or so before the doctor goes in and realizes she's not drunk at all. It's another 4 hours before they can get her stabilized and transferred to the other hospital in town, like 13 blocks away or something, but it has the neurosurgical facility. So 4, 5, 6, like 7 hours into the event before she's finally in surgery having the pressure relieved off of her brain. Well, as a result, Sarah Schulman has permanent neurodeficits. Of course, wouldn't be talking about it if she didn't file a lawsuit. What did the lawsuit say? Well, it said, according to Wright versus City of Los Angeles, when the medics arrived to commence their assessment, their duty attached. Totally did. Under Zepeda versus City of Los Angeles, they were not reasonable in the way they handled those signs and symptoms, the potential of those signs and symptoms. They were not. The attorneys for the county, very aggressive, very good, very well trained, they said how much? And out came the checkbooks and they settled the case. So the takeaway is don't do that. Don't judge. Don't assume you know what you're going to find when you arrive on scene. That's the obvious takeaway. That's not the real takeaway. That's not the most important takeaway. The most important takeaway from the Schulman case requires that we go back in time. Let's go back to the moment these paramedics arrived on scene. And let's say that instead of being judgmental and assuming they knew what was going on and not bothering to do their job, let's say they were the best paramedics in the history of EMS. Let's say that these guys were so good that when they arrived on scene, they took one step out of the squad and they said, wait, smell that? That's a bleed. Let's say they were that good. And let's say they aggressively treated and rapidly transported her to the hospital. Let's say that it didn't take 20 minutes or 25 minutes at all. Let's say they had that underground Elon Musk time traveling wormhole thing, and let's say it takes 5 minutes to get to the hospital. And let's say that they didn't even bother with the first hospital, but they went straight to the second hospital. Let's say that they didn't bother with the emergency department at the second hospital, but they went straight into the neurosurgical suite where the world's greatest neurosurgeon was already scrubbed up and ready to go. And let's say that within 7 minutes of their arrival on scene, Sarah Schulman was in surgery having the pressure relieved off of her brain. Would she still have permanent neurodeficits today? Maybe. I don't know. Maybe yes, maybe no. There's no way of knowing. But what we know for sure, and the bigger takeaway, is that every minute these guys spent on scene, not doing what they were supposed to have been trained to do, not doing what policy and protocol and procedure require that they do, not doing what they promised they would do when they took the job, was 1 minute farther away than Sarah Schulman got from the possibility of a full recovery. Which leads us to the most important takeaway, and it's this. Every one of us has been taught or made to believe that we are in the life-saving business. Well, not me anymore, but that you are in the life-saving business, that if you respond to 911 calls or you run out to treat patients, you're in the life-saving business. You are not in the life-saving business. You never have been. EMS has never been the life-saving business. If it was the life-saving business, you would fail a pretty fair amount of time because people die. That's a thing that happens. If whether someone lived or died was the measure of your success, you would not make it to the Hall of Fame simply because people die. Not every call results in a good outcome. And the law recognizes that. The law says, hey, I get it and I'm cool with it. The law says you are not in the life-saving business. The law says you are in the possibilities business. You are in the business of doing everything you can, everything within your power, everything within your scope of practice, everything within your skill set, everything to create the possibility of a full recovery. And if that happens, great. When you save a life, it is one of the best feelings in the entire world. But if the patient dies, the law says, it's cool. I'm cool with you, okay? The law, believe it or not, is very forgiving. Live, die, good outcome, bad outcome. The law will forgive. The law is totally cool with all of it if you have done everything you can to create the possibility of that good outcome, to create that possibility of a full recovery. The one thing the law will not forgive is the lack of effort. If you don't give 100% on every single call, the law will be a problem for you. It will be your sword. It will be the sword used against you. But if you give every single patient the best of everything you have, every call you go on, no matter what, the law, the Schulman idea will be your shield. Okay? That is the bigger takeaway. Now, we are rounding the corner on the first hour. We're going to end this first hour with maybe one of the most important things I could teach any group of EMS providers, and that is about negligence. We are taught, all of us are taught, that if we mess up and make a mistake and, we're going to be negligent and lose all our stuff. That is absolutely not true. I would tell you, don't worry about being sued because you've got too many protections and it's almost impossible to sue a provider, but I can't, because you're going to get sued. It's going to happen. If you're in this business long enough, someone's going to file a lawsuit against you or complain against you or allege something against you. You can't stop it. There's nothing you can do to stop it. We somehow live in a society where people just feel free to say whatever stuff they want without understanding, believing there's not going to be any consequence for them or for you or for somebody. So I don't want you to ever be afraid of being sued, because there's nothing you can do about it anyway. However, while you're on every call, from beginning to end, you are the only one that has total control over whether that person can win their lawsuit, over whether that action can succeed against you. On the call, in the moment, you have total control over how it ends. You can't control what happens next, but you can control how it ends. And understanding negligence, I think, is probably the most fundamental, best way to do that. The rule for negligence is pretty straightforward. Where one owes a duty, breaches that duty, and that breach is both the actual and proximate cause of the plaintiff's damage, then you can be held liable for negligence. Blah, blah, blah. It's too many words. You only need to know 4. Duty, breach, causation, and damage. Duty, breach, causation, and damage. I'm going to say it one more time. I'm going to be a little bit dramatic, because from this day forward, every call you go on, as you're approaching that call or approaching that scene or approaching that patient, I want you to hear my voice in your head saying duty, breach, causation, and damage. Because for negligence to be what we call actionable, for them to be able to succeed in a negligence claim against you, all 4 of those elements have to be true. They all have to be present. They all have to be proven. If any one of those elements is missing, if any part of any one of those elements is missing, then no matter how terrible the breach or awful the damage, you can't be held liable for negligence. Okay. Now, it's really important to understand that the theory of negligence, the kind of negligence we're talking about right now, is simple negligence, pure negligence, the most basic root form of the claim. There are countless other offshoots with different rules that have different. Don't worry about any of those. If you understand this one and how it works and how to function within it and how not to get caught up in it, the rest won't matter. Okay. So let's talk about each one. Duty. If I were to ask anybody watching right now, what is your duty? You would tell me something like duty to act, duty to respond, duty to do no harm, duty to blah, blah, blah. Doesn't matter. Anything you said would be correct, because all of those are true. But I'm going to submit to you that EMS providers have one overarching duty that covers everything. And that is, I would argue, you've got the absolute duty to respond to the needs of everyone who calls. Because we know that not every call you go on do you arrive to find a fire or rescue or medical need. In fact, I would hazard a guess that more often than not, you arrive on scene to find a situation for which 911 was never created in the first place. However, you do arrive to find something. And when you arrive to find something, and that something is a someone who called you, even though there's no fire, rescue, or medical need or need for which 911 was called, that person does need something. Imagine the little old lady who calls in the middle of the night to have her bed sheets changed. Okay, that was a real call. That actually happened. There's no fire, rescue, or medical need, no need for which 911 was created. In fact, there's no legal obligation whatsoever to change those bed sheets. But you can bet if you want to get into heaven, you are going to change those sheets, and it's going to be the best bed you ever made in your life. Clearly, she does not have a need for which 911 was created, but she does need something, right? Clearly, if she's calling 911 in the middle of the night or any time for that, clearly she's not fully able or capable of completely caring for herself. And in that moment, 3 o'clock in the morning, no one's out, no one's up, nothing's happening, there's no office you can call. There is something you could do in that moment to try to meet that need. How about we ask, you got any family? Anybody we can call? Oh, yes, my daughter lives in, I don't know, pick a yucky town near you. You call her up on the phone. Hi, this is, provider, this is so-and-so. Sorry, we're here with her. Don't worry, she's totally fine. She's totally fine. She called us out to change her sheets, which we did, because we want to get to heaven. But it appears that she's having a tough time caring for herself. Can you come in and check on her? Okay. Now, legally speaking, absolutely no duty to make that call whatsoever. Why'd you do it? You did it, hopefully you did it, because it's the right thing to do. That is ultimately, at the end of the day, that is the duty, right? To do the right thing because it's the right thing to do. And if your attention to doing the right thing on a stupid little, I can't believe I'm on this unnecessary call like that in the middle of the night, if your attention to excellence is all the way up here on that call, where's it going to be on that pediatric CPR, on the shooting or the stabbing? Where's it going to be on that call where they genuinely, absolutely need you? By default, your attention to excellence is going to be up here where it belongs, because that is the promise you made. That, I would argue, is the duty. Everything else falls within it. Breach is probably the easiest concept in all of the law. You were supposed to do a thing and you didn't. You were not supposed to do a thing and you did anyway. That's breach. That no more complicated than that. Causation acts as kind of like the nervous system of negligence, right? If duty and breach is the skeletal and circulatory system, causation is the nervous system. It's the thing that connects all of the rest of it. Causation is just some fancy lawyer way of saying it caused it. It's your fault. You did it. Okay. Causation, meaning you caused the damage, your breach caused the damage, has to exist on two levels at the same time. The first one is what we call actual cause. Before a claim of negligence can succeed against you, your breach has to actually cause the specific damage, meaning but for your breach, that damage would not have occurred as, how, and when it did. Okay? But it's not enough for a claim of negligence to be true or actionable. It's not enough that your breach actually caused the damage. Okay? The damage that your breach actually caused, meaning but for your breach, the damage wouldn't have happened as, how, and when it did. The damage that your breach actually caused had to have been foreseeable. That's what proximate cause refers to. Foreseeable based on the breach itself. So based on that specific breach, that specific damage was foreseeable. If it wasn't, then even though you might have actually caused it, if that specific damage was not the result of the breach foreseeably, then you're not negligent. Here's the example. You're on an overdose call and you give Narcan, right? Right up the snot locker, some Narcan, it goes. And the patient begins to bleed profusely from the eyes and the ears because the drug manufacturer put the wrong drug in the vial. Let's say you forgot to check the expiration date. Yeah, you gave a drug without giving the expiration date, and that's definitely a breach, and you definitely caused that damage by injecting that, what you thought was Narcan. But you can't be held liable for negligence because it's utterly unforeseeable that the contents of that syringe would be anything other than the label said. So all of the elements have to be met. Damages. In order for a claim of negligence to be actionable, there has to be some quantifiable monetary loss. You can't just have pain and suffering. You can't just have punitive damages. There has to have been some quantifiable monetary loss, some you break it, you buy it, some actual thing you could put a dollar amount on, okay? Once you have all that, then and only then can negligence be actionable. Now, you now know as much about negligence as you need to understand this. As long as you understand and you know and you comply with your policies and protocols and procedures, and you never violate them, meaning you never breach those duties in any way, then no matter what anybody else alleges against you, the facts will come out that it's not true. The facts will come out that you are not liable. Okay. However, there are 3 things you can do on every call. And if you do these 3 things on every call, you will absolutely be as safe as you can possibly be. Imagine yourself in a shark cage, right? You're in the ocean and lawyers and sharks are swimming all around you. Great, have a good time, enjoy the view. As long as you stay in your cage, nothing can get you. You do these 3 things on every single call, that cage will be made out of titanium. Nobody's getting through. The first thing is perform a systematic assessment. I say systematic and not thorough because every assessment is thorough or it's not an assessment. I say systematic because if you get yourself into the habit, if you develop the muscle memory to do your assessments the same way every single time in the same order, and you have that habit and the muscle memory, and you do it that way every single time, it's predictable, then in those moments when your head's not in the game, you're just not feeling it for whatever reason, nothing gets left out. Okay. Every assessment is thorough or it's not an assessment. If every assessment for you is systematic, then it's going to be nearly impossible for anything to be left out and the patient gets everything that they deserve, that they need to get. You keep your promise. Once you've done that, provide appropriate medical care. I know it's crazy. I came up with this all by myself. But appropriate medical care isn't necessarily what you think it is. Appropriate medical care is always only ever the care or the treatment that's indicated based on the policies and procedures and protocols associated with the objective findings of your objective assessment. It's never based, it can't possibly be appropriate medical care if it's based on your mood or your want or your assumptions, what you figure, what you think is going on. No. It can only be appropriate care if it's based on the objective findings of your objective assessment and the associated policies, protocols, and procedures. Once you have done those 2 things, then and only then is it possible for you to maintain accurate and complete documentation. Kids, that is negligence. That is the law. That information is absolutely what will keep you safe. By now, hopefully you have gained kind of a good fundamental skeletal understanding of the law and how it affects you. I want to spend the rest of our time together today. I want to give you the opportunity or give you the tools to put it to use, right? Because what value is it if you can't use it? And I think the best, most effective way to do that is through the lens of documentation, because documentation truly is kind of the thing that connects all of EMS again, because, well, we'll get to it. All right. So yeah, that's what we're going to talk about next through the lens of the law, and understand that I am not going to, and I would never bother wasting my time or yours trying to teach you how to document. Any class you go to, if you're an EMS provider and somebody gets up in front of the room and says, all right, everybody, I'm the expert on this subject, and I'm going to teach you how to do this thing. Unless it is a skill that has a required order of progression, unless it's that, anybody who gets up in front of a group of EMS providers and tries to tell them there's one right way to do things, I'm going to teach you how to do it, they don't know what they're talking about or who they're talking to. That it would be a monumental waste of time, because you're going to do it your way, the way you do it. Every one of you has probably gone to a documentation class, and none of you documents the way you were taught because you've got your own style, your own way of doing it. Perfectly fine. What matters is, and the law is going to be the framework with which we get, what matters is that you know what to document and why. If you know what you're documenting and why you're documenting it, the how will ultimately take care of itself. Okay. The object of the game, when it comes to crafting your documentation, the object of the game, there's 3 parts. Number 1, identify your audience. Who are you writing this for? If the patient is going to the hospital, you are writing it for the receiving facility. We'll talk about that in a second. If it is a dead body that you're leaving on scene, you are writing that for the coroner, homicide investigator, insurance investigator, maybe. That's your audience. That's the story you want to tell. If it is a refusal you're documenting, then that's pretty much for the lawyers. That's the story you want to tell. So identify who your audience is. Number two, once you've identified your audience, think to yourself, what would they want to know? What questions are they going to have for me about this call? Which brings us to number three, the most obvious one. In your documentation, as we're about to discuss it, the object of the game, number three, is to answer their questions, whoever your audience is, answer their questions before they have a chance to ask. Best case scenario, you answer everyone's questions before anyone has a chance to ask. And then best case scenario is you run the call, you finish your documentation, you upload it, and never see or hear about that call ever again. Because if anybody ever had questions about it, they said, all right, let's take a look at this thing, and they look at it and they read, and they read what you wrote and they read what you included, and they say, okay, I've got no questions for you. Best case scenario. Okay. Now understand that documentation is not a chore. It feels like it. It's a pain in the backside, and I hated it too, but it's not a chore. It's not something we just have to do because we ran a call. Documentation, for all intents and purposes, is by its very nature care for the patient, especially in situations where the patient's being transported to the hospital. If the patient's being transported to the hospital, what you write, your documentation, is the thing that is going to tell the next level of care provider what they need to know so they can provide continuity of care. They can know what happened before the patient got there so they can know what to do next. And fundamentally, every report matters. Now, we all know, let's just speak truth to power here. We all know the receiving facility does not read your documentation. They absolutely do not read what you wrote unless they need to. The only reports they're reading are the reports they absolutely need to read because they've got questions they need answers for right now that they can only find in your documentation. And if it is not there, well, your lack of inclusion of that information could contribute to the inability to care for the patient. Ultimately, extrapolate that all the way down to its natural end, that could end up constituting negligence. Okay, every report matters. Now, when we talk about documentation, I am now, for the remainder of this discussion, referring specifically to the narrative. The narrative is where your documentation lives and breathes. The narrative is where the story is told. Check boxes and drop-down menus, fill in the blanks. These are all very, very, very important fields. Probably most consequentially for data gathering and data processing and analyzing and collating and learning more about EMS than we've ever known. But in court, they're going to be basically useless to you. They're not going to do anything to refresh your recollection. And in court, when you get called to testify, and mind you, you're going to get called to testify, not because you did anything wrong, but because you were on a call and somebody's mad at somebody else and you were there, you saw something, and one side or the other, or both sides, there you go, is going to have questions for you. Okay, someone's going to have questions for you. If you don't remember the call, and if reading your documentation doesn't refresh your recollection of the call, and it's not written, that's where we get the old maxim, if you didn't write it, you didn't do it. We know that's not true. We know there's lots of stuff that happened on calls that doesn't get written down. Doesn't mean it didn't happen. The maxim really should be that if you didn't write it and you don't remember it and you can't testify to it, then the presumption is that it didn't happen. So refreshing your recollection, telling the story, that's what we're doing. That's why we are talking specifically about the narrative. Now, what goes in the narrative? That's easy. Every call you go on, there's a circumstance that led you to that call. If the circumstance is that there's a patient, great, best case scenario. For every patient, there's an assessment. For every assessment, there's findings. For every findings, there's some protocol to follow. And for every protocol, there's some procedure to execute. That's what goes in your narrative. Now, you just thought to yourself, whoa, that's a lot of information. It is a lot of information. It does not have to be a lot of words. And in the full 3-hour version of the documentation class, I go through narratives, and you can see what I mean by that. We don't have the kind of time to do that today. But yes, it is a lot of information. The patient deserves, the system deserves, the job requires that you include a lot of information, but it doesn't necessarily need to be a lot of words. Now, some calls you go on, there is no patient. Sometimes you arrive to find just a caller or no caller at all, just your drugstore, middle of the night parking lots, an assault call or whatever, and nobody's there. Well, you still have a procedure to follow, right? You can't just go, oh, nobody's here, and then write unable to locate. You still need to do your investigation, look around, turn those big LEDs on and kind of look down the side and contact dispatch or PD or the reporting party, or make some reasonable effort to try to find the guy. All of that, all of the things you did to determine you were unable to locate, all of those things go into your narrative. There is no call you can go on that doesn't require a full and thorough narrative. Let that sink in, because some of you might be thinking, whatever, trust me, don't trust me. You can either trust me now or pay me later. I'm cool either way. Let's put it together and put it into concept. And Captain Morgan and I, years ago, came up with this mnemonic: patio, documentation on the patio. I don't expect anyone to remember. I don't expect you to leave this class today, or this discussion today, remembering that documentation should be prompt, accurate, thorough, intelligent, and objective. If you never think to yourself, prompt, accurate, thorough, intelligent, and objective ever again, that will be perfectly fine not to remember prompt, accurate, thorough, intelligent, and objective, because not everybody knows the documentation needs to be prompt, accurate, thorough, intelligent, and objective. See what it did there? Yeah, I totally just did that. All right, let's see what they mean. If you are going to be good at this, if you are going to do this thing, then your documentation needs to be prompt. That means if you are transporting the patient to the hospital, you are completing the report before you leave the hospital. Think about the reason why. Stop. Every one of you just thought to yourself, there's no way, we don't do that. Our system doesn't allow for that. Stop, clear your heads, okay? Because for generations, providers finished their documentation before they left the hospital, so you can do it too. Understand the reason why, the legal reason why. If the purpose of your documentation on a patient who is transported to the hospital is the furtherance of continuity of care, you cannot possibly accomplish that by packing up, leaving, and doing it sometime later. Because between now and sometime later is when they're going to need the information you didn't provide them. You will have done that patient a disservice, and the law is not going to be your friend. Okay? So, if you are going to be good at this, and if you are going to do this the way it was meant to be, your documentation for patients who are transported should absolutely be done at the hospital before you leave. You're thinking to yourself, now that you've taken a breath, you're thinking to yourself, does he mean to the exclusion of other calls? Like, don't go on any calls? I do mean that. Put an asterisk in it from the real world. We'll get to the real world in a second. But let's talk about the legal world first. The legal world for a second. Think about Wright versus City of Los Angeles that tells us our duty to the patient is not extinguished. That relationship is not extinguished unless and until we've done all of the things that policy and protocol and procedure require us to do to terminate that relationship. Documentation, finishing your documentation, is one of those things. So if you piece out from the hospital and do your documentation later, technically, legally, the law might say, well, you abandoned that patient, or that's still your patient, or you're not done with that call, or whatever it might say. That's the reality of it. Now, that's the legal reality. Let's go to the real world. The real world is, if you are at the hospital and the patient's being treated and you're doing your thing because I told you to, and another call goes out and you are substantially closer than the next closest resource, of course you're going to take that call. You have to. You better jump that call. You better handle that call. Okay? It would not be reasonable to sit there and handle your paperwork while another call right down the street from the hospital is going down. Okay? However, don't let your documentation stack up. That is the danger. Let's say that you find yourself backed up on 2 or 3 or 4 back-to-back chest pain calls, and you're finally sitting down to catch up on all of them, right? Is you catching up on all of them. Human nature demands that you are invariably going to transpose the information of one patient onto the report of another, potentially not on purpose, just, accidentally, potentially doing a grave disservice to both patients. Not to mention subjecting yourself to the potential claim of wanton fraudulent documentation. If you don't believe me, I've seen that here in California, okay? So your documentation needs to be proper. Now, if it's one of those calls where it's nothing showing, just do it. There's no need to let it stack up. Do it as soon as you can. If, however, it is a refusal, an AMA that you are handling, I'm telling you right now, prompt means you are not leaving that patient's side until you are done with your documentation. Before you think I'm crazy, I have an M. Night Shyamalan twist ending to all this. It's going to make perfect sense. Just put a pin in that for a second. Documentation needs to be accurate. I think we can all pretty well agree on a common definition of what accurate means. True, correct, a complete reflection of everything that happened. We get it. What I want you to take away from this slide is that no matter what you want to think, no matter what you assume, it is never the same call. Every unit, every jurisdiction, every station, every area has their frequent flyers. They've got the patients, the houses, the calls. They go on every shift. They know the people. On the way, you could hand the name, date of birth, meds, allergies, history, all because you know them so well. Like you know what you're getting into, right? But you can't afford to assume you know what you're going to find when you get there, because then you get caught up in the vortex of confirmation bias and you end up in a Schulman situation. To give it like this, the way the law looks at it is that every call you go on while you are on your way to that call before you arrive, every call is the single most critical, single most righteous, single most important call you're ever going to run in your entire life until you get on scene, assess, and objectively prove otherwise. Then you handle whatever it actually is. But you cannot afford to have the mindset that it's going to be garbage before you get there, because then you're going to turn it into garbage and you're going to end up in a Schulman situation. Be thorough, paint a picture, tell a story. Don't be afraid to put a bit of yourself into that narrative. Let the reader kind of feel what it was like for you there. Be detailed, right? Include Easter eggs for yourself that might later on down the road help remind you about that call, okay? It doesn't have to be long, but it should be detailed. That sounds crazy. Read the book. See what I did there? It's just a little more books. However you put it together, however you do your narrative, doesn't really matter. I don't care. If your area cares, that's on you. Nobody really cares how you assemble it, as long as it is clear and organized and it makes sense. As long as the reader can get from the beginning to the end and understand what it is you are trying to tell them, understand what happened, as long as their questions are answered, okay? That's what that means. Now, stay objective, stick to the facts. The only thing any provider could possibly know for sure on any call is what they observe with their own senses. If you hear it or feel it or smell it or touch it, then write it that way to tell the reader, hey, I did this thing or I saw this thing. If you've got any questions about it, you can come ask me and I'll tell you. Everything else is somebody else's story. Patient states, I don't know, you got to ask the patient. Bystander states, I have no clue, you got to ask them. Police, PD also reports, I have no clue, you got to ask them, okay? Attribute the source. If it's not your finding, it's somebody else's story, tell the reader to talk to them, okay? Truly, truly, truly avoid opinions. As much as we would like to think our opinions matter, they absolutely do not. Now, let's really put the law into action, and let's talk about the two areas where if you are going to find yourself at trouble's doorstep, it's going to be these two situations. First, shipping patients BLS. Now, quite frankly, I don't know who I'm talking to out there, and I don't know how your system works, but I do know that the ability for ALS providers to send patients to the hospital in BLS only ambulances has been around forever, and it's only getting more popular. The more busy systems get and agencies can't meet the demand with all ALS resources, we find ourselves in environments where paramedics on scene are turning patients over to EMT, BLS only ambulances and sending them to the hospital. Now, I'm not a giant fan of that for lots of reasons, but it's a thing that happens. It's a thing that has to happen. Okay. Now, understand the context of what I'm talking about now is this. You are a paramedic on a paramedic unit. You arrive on a call. Doesn't matter what the call. Let's say it's a stubbed. A guy kicks a pinky toe into the coffee table, and for whatever reason 911 got called. Okay, that's as BLS as it could possibly be. You're the paramedic on scene, and for whatever reason the guy wants to go to the hospital by ambulance. So you put the patient in the back of a BLS only ambulance. Perfectly appropriate, as long as you understand you have not transferred care. There is no such thing as a transfer of care from a higher level of medical authority to a lower. You are transferring custody. And as you close those doors and you wave goodbye to that ambulance, that is still your patient. And if any foreseeable adverse event occurs, you are going to own that. So if you are going to make the decision to ship a patient BLS, or for that matter, if you're going to make any decision in EMS, make it a core decision. Core meaning the decision you are making is clinically based, that clinical basis is objective. It's not based on your wants or your needs or your mood. It's based objectively on your objective findings of your objective assessment. The clinical basis for your decision is objectively reached. That objectively reached clinical basis is righteous, meaning it's the right thing to do, meaning it's what you would want done for you or your family or somebody you care about, okay? That righteous, objectively reached clinical decision has to be explicable, meaning anybody who comes asking, a supervisor, a detective, an investigator for the licensing agency, a judge, a lawyer, anybody comes asking questions about this decision, the explanation will be rational, logical, and reasonable. It will make sense. If every decision you make in EMS is a core decision, you're going to be probably just fine. Okay? Anything else, and there's a consequence, you can't throw your bottle on the floor and cry because you don't have it, which leads us to patient refusals. I save patient refusals for last because this is about the most critical, the most dangerous medical situation you can find yourself in, because once you leave and all the liability stays there. Refusals are a thing that happen, but as we saw in the Hackman case and in the Wright case, they don't always happen the right way, okay? So the first question we have to ask ourselves before we can even think about allowing a patient to refuse is, are they legally permitted to refuse? And right off the top of our head, there are two patients who can't legally refuse, right? The minors and the altereds. They have no say in the matter. But they're not the only ones, are they, right? You got minors and altereds. You've got individuals that lack capacity. You've got individuals over whom there is a conservatorship, and individuals over whom there is like a 72-hour, like a 5150 type psych hold. There's actually 5 categories of patients that cannot legally refuse care for themselves. If the patient you are encountering finds themselves in one of those groups, then you're the boss of them, effectively, okay? A refusal is not a refusal unless it is informed, and it's not informed unless you have advised the patient of the specific risks and consequences of the specific diagnosis. Now, I get it. We're not supposed to diagnose in the field, but of course you do. If you don't diagnose, how you know what to treat? Okay, I get it. You got to call it clinical impression or whatever. I'm just going to use that word because it's right. Okay, it's not enough to just say, and we've all done the same thing. It's not enough to say, advise the patient of all the possible risks and consequences of refusing care up to including death, right? And that sounds great and it feels good, but it's not true. It's a total lie. It's a lie because you can't possibly have advised them of all the possible risks and consequences because you don't know all of them. You're not a doctor. I'm not a doctor, even though technically I am. We went through that already. So we can't know what all the possible risks and consequences are. But when you do your assessment, you reach a conclusion, a diagnosis, a clinical impression of what you think is most likely going on. That is the thing about which you are going to inform the patient. Look, I believe based on what I found, I think it could be this. And if it is this, these are the very specific risks and consequences. It could also be maybe this and maybe this. I picked two or maybe three of the most likely candidates. And if it's these things, these are the specific risks and consequences. Okay. Explain it clearly to them. Here's the really bad news. And this is why I was telling you that we got to finish all the documentation while we're on scene. While you're doing that, and I'll tell you a second, while you're doing that, somebody on the crew in real time is documenting all of it in crazy detail into the narrative. Okay. Now, the refusal we're talking about right now is the patient that you absolutely truly believe needed to go to the hospital. I'm going to give you the best practice for that patient, and then you can scale it however you need to based on patients with a lesser acuity. Okay. I'm going to, where the conversation we're having right now is the most serious patient who absolutely needs to go. You can scale it down from here. Okay. So just so you don't think I'm nuts. Okay. All right. So in this instance, somebody is taking it all down in real time. I promise you there's a reason why. Okay. It's not enough. The refusal is not informed, no matter how specific you are, if the patient doesn't understand what it is you're saying. So you have to confirm that they understand what you're saying. And you can't confirm that by saying, do you understand what I said? Because they're going to say yes. Okay, cool. Repeat it back to me. What did I just say? There's something about the act of repeating it back that solidifies it in their brain and gives it more meaning. And remember, what we're trying to do here in this instance is get them to make the right decision, which in our professional clinical opinion is to go to the hospital. We are trying to get them to go. We are creating every possibility for them to make the right decision. Okay. Repeat it back to me. What did I say? Oh, you said it was this, or this, could be that, whatever it is. Meanwhile, whoever is documenting, probably the guy with the brass on his collar, is taking all of that down in real time. And now what you're thinking is, dude, that's going to take longer. That's going to take more time. Yes, it absolutely is going to take more time. What I'm telling you to do right now is the best practice is probably going to add 5 to 7 minutes to your on-scene time, maybe 12 if you're really slow on the keyboard. Okay, but I'll ask you a question. Is 5 to 7 or 12 extra minutes spent trying to do everything you can to get this patient to make the right choice a better investment than 3 to 5 years down the line involved in investigations and litigation and depositions and lawyers and headaches and stress, right? You pick, right? You do whatever you want to do, okay? Now, remember that you're not generally, some places are, but generally speaking, most providers are not alone out there. You've got online medical control. That's great. I love online medical. I love base hospital contact because number one, you get to share some of that liability with another source, right? It's recorded, so there can be no dispute or doubt about what you said or did. But I think the most valuable thing is you get another perspective, right? Imagine, and this is a call that I was on years ago. Imagine a 30-something-year-old patient, male, pale, cool, diaphoretic, jaundice, bright red blood and dark tarry, like just bleeding out of both ends, just as bad as you can be. Blood pressure barely palpable around 50, pulse in the 130s, thready, barely palpable, reps at like in the mid to higher 20s. And the guy was struggling, but alert and oriented times 4, no capacity issue, no psych issue, and he absolutely refused care. Didn't want to go to the hospital. And I tried everything I could. As you might imagine, I was pretty good at getting people to do what they didn't want to do. Man, I got someone to marry me, so I'm good at that. My partner tried, the fire captain tried, the police officer on scene tried, the wife tried. We tried everything we could think of, nothing doing. So I made base hospital contact. I documented the refusal and got the patient to talk to the nurse. And the nurse tried the best she could. We got the base hospital physician on the phone, nothing doing. We went so far as to get the base hospital chaplain on the phone with the patient, on the radio with the patient, to try to convince them to go. We did everything possible. We used every resource we could until we ultimately had to say, all right, well, some don't want to help, some don't get to help, okay? Remember that you can be creative in getting people to do what they need to do. Remember, the conversation we're having right now is giving the patient every opportunity to make the right decision, which we believe in this instance is going to the hospital. Your narrative is going to be extraordinarily detailed, and it's going to be created on the spot. Yeah, sorry. You think I'm nuts? I promise I'm not crazy, because I'm going to give you an idea. Once you have done all of these things that I've told you, once the patient has been advised, once they've repeated it back, once all that is documented, once they've signed the AMA, I'm going to suggest that you try one more thing. And that is to have the patient take their grubby little COVID fingers and type their name into the body of the narrative, acknowledging that they understand that all of the above is true and correct. Nobody does that. It's completely unorthodox, but I'm telling you, if you do that, there's two things that can happen. Number one, the physical act of doing this is weird. It's unusual. The patient's not going to have been expecting that, and it's going to cause a connection with the brain that makes them ultimately possibly rethink their decision. God, if they're having me do this, they must be serious, because this is weird. I wasn't expecting this. Maybe I should go to the hospital, which is all we wanted from you in the beginning. Or, fine, I'm out of here later, dudes, and they're gone, and the thing that you warned them about happens, okay, and they get a lawyer to try to sue you or your agency or whatever, okay, the first thing the lawyer is going to do is going to look at that run report and say, dude, not only did you sign the AMA, and not only did you acknowledge all this is true, but you typed your name in. We have absolutely no case. And you're never going to know that happened, because what you did 8 months ago or a year ago on a call you've long since forgotten, the extra 7 or 12 extra minutes you spent kept you so far out of trouble that you never even knew there was any. And that's great for you. That's like the good selfish part, for us. But the collateral benefit is you get to go to sleep every night knowing you did everything humanly, remotely, crazily possible to get this patient to do the right thing. And they can't throw their bottle on the floor and cry because they don't have it. Your documentation, your understanding of law, this is the cage. This is the thing that's going to keep you safe. This is the thing that lets you swim with those predators, the lawyers, and not have to worry about it. Okay, they can say whatever they want. They can bite at that cage, but they're not going to be able to get you. And this is the only way you're ever going to have the kind of control that allows you to prevent that from happening. Now, Einstein defined insanity as doing the same thing over and over again, expecting different results. I would define insanity as expecting to excel at something you don't practice. In the fire department, every day, they're drilling with hoses and ladders and saws and tools and things and equipment, because there's just not that much fire. When you arrive on a fire scene, you got to have those skills at your fingertips ready to go. There's no time to forget how to do a skill you don't very often do. Isn't the same thing true in EMS? Oxygen, IVs, EKGs, CPR, stuff you do all the time, great. You're practicing whenever you do it. But IOs and thoracotomies and needle crikes and some of these procedures that almost never get done, are you practicing those with any frequency? And if you're not, why not? Every call you go on, if you've got to do one of those procedures, the system, the law, the promise you made expects you to have those skills at your fingertips. And if you don't, can't throw your bottle on the floor and cry because you didn't have it. As we're talking right now, everybody out there in your area, without knowing it, they're not thinking about you at all, but they know you exist, and they have no clue that they're depending on you, that they're counting on you. Right now, as we're having this nice conversation, they're out living their life, not thinking for 1 second that with one unpredictable twist of fate, they're going to come to depend on you. Maybe today, they're going to come to depend on you to determine whether they live or die. And which one of you are they going to get? If that's not motivation enough, think about this. If you work a 24-hour, it doesn't matter. You're on shift somewhere and you're sitting quietly trying to relax, and you pick up your phone and call 911 for help. You know who you're going to get? You're going to get you. There is no 1011. There's nobody after you. You are the end of the line for everybody, and for yourself, and for your partner. Who are we going to get? We call you. By the way, Sean, before we get to questions, I want everybody, see that red, the 310-699-0070 number on the screen. That's my cell phone number, okay? I want you to program that into your phone. One of these days, if you've got a question and you wish, you had a lawyer to talk to, let's say you ran a call or something weird happened, or I don't know, whatever it is, and you wish you had a lawyer you could call just to bounce something off of, and you don't want to pay for that lawyer, you got one. It's me. Call me. I will take care of you. As long as I can guide you and help you and make it, easier and safer and better for you, I'm going to do that, because that's how I get to stay connected with my first love, with the industry that I love so much. Understand that if you're not in California, I can't practice law outside of California, but I can entertain hypotheticals about anything you want. All right. I will never charge you for that. Okay. It's going to be my pleasure to help you. However, if you're in California and you really mess up and you need my lawyer services, that's expensive. So save your nickels and dimes.
All right, so these are, I'm just going to read them straight from how we got them, and we're not going to filter any of these out of here. So we're just going to throw them at you exactly the way they are. So here's the first one. If I make a mistake with patient care and they find out it's because I was working a 48-hour shift with no sleep, could I get in legal trouble?
Maybe. If you knew that you were fatigued to the point where you could not reasonably provide the service expected, and you work anyway, then yes, it's in the law, we call it the KNEW, knew or should have known standard. If you knew or should have known that your fatigue would interfere with your ability to provide service, then yeah, you got to step away. So the answer is yes.
Great. Here's your next one. If I stop at a car wreck off duty and touch a patient, but then decide I can't stay and leave before fire and EMS arrive, can I be liable for anything?
Absolutely. So here's the problem with that. Generally speaking, when you assume care or treatment of a patient or a situation to the exclusion of someone else, then you now own that until further help arrives. To give it like this, let's say you and your buddy are on the beach, right? And you're laying on the beach, and you're the best swimmer, you're lifeguard of the year, you're like the best water rescue person that's ever been born. You're laying there on the beach, you're on your towel, and you're talking to your buddy, and it's all good, and it's great, having a great day. And you look out there and you can see a guy clearly drowning. And you say to yourself, that sucks, that guy's gonna drown. Hey, did you know that guy's gonna drown? Yeah, that guy's gonna drown. And you start taking bets on how long it's gonna take for him to drown. Other than maybe illegal gambling, no crime, no offense. There's no obligation to come to the aid of another unless there is a special relationship. And if you're just a guy at the beach, there's no special relationship. However, if you get up and you say, I'll save you, and you go running toward the water, somebody hears you say that, somebody who would otherwise have jumped in to help the guy hears you say that, sees you running toward the water, turns around and walks away, and then you get to the water, oh shit, that's cold, and you go the other way, you now have liability for that rescue, okay? If it is to the exclusion of someone else who would have helped, you absolutely would have. If you initiate care and create that expectation, I believe the law says you've got a duty. Now, since we're talking all nice, let's keep talking about it. Let's say you do get in the water and you're swimming over and you're like, oh man, I'm the best swimmer, this great, water feels great. And you got like, 50 yards to go, but you see like, 3 dorsal fins swimming around the patient, okay? You're like, later, and Jesus walked back to the shore. No liability, because as it is on the job, the same as off, your personal safety takes priority. You are not required to effectuate a rescue where you reasonably believe you would face grave danger. That guy's dinner, you're back on the beach safe. I hope that answered the question.
Yeah. So here's the next one. This is a patient scenario style question. So we're taking care of an elderly patient with a known stage 4 cancer, and they have a physician order of life-sustaining treatment form designated full code for that cardiac arrest. There's no power of attorney. Family on scene agrees the patient would not want any CPR done. Your protocol states that we should do everything. So what should we do in that situation?
That is a silly question. You answered the question. The protocol says do everything, do everything. And whoever wrote that question, I apologize if I made you feel silly for asking, but I wanted to illustrate that sometimes the answer is in the question. If there is no DNR, if there's no pulse, if there is no legal document that you're allowed to acknowledge that says otherwise, and just the family says, oh, they wouldn't want anything done, that's not enough. because you know who that family is? That's a family that's going to sue you when you don't do anything. It's a trap. What they say in Star Wars, it's a trap. Okay. You absolutely, your protocol tells you are required to do everything. Let's flip that around since we're talking all nice. Okay. There is a DNR. It is a very clearly executed DNR. And you go to the house. The patient is not on hospice, but is a late stage disease process of some sort, is in full cardiac arrest, early enough that you could, reasonably treat. Doesn't meet any criteria. And the wife says, do everything you can to save my husband. And you look at the DNR and it says, don't do anything. If you were to ask me on instant speed dial, I would say you do what the wife says for two reasons. Number one, she's the wife, she's there. And if anybody's ever been married, you do what the wife says. Okay. Number two, if the patient is salvageable, right? And you would know what that looks like when you're there. Why give that wife the rest of her life to wonder if everything that could have been done was done? Which is the right thing to do? The law will side, when there's a dispute, when there's a tie, the tie goes to the runner. The tie goes to what would have been the right thing to do.
What is the best practice for 911 systems to deal with 911 abusers? The example given is frequent callers with or without non-emergent symptoms.
I don't know what to do, but I know what not to do. And what not to do is to educate them or inform them or tell them on the call, don't call 911, or don't ever tell someone what not, here's why you don't call 911. You don't ever want to create the perception that you're trying to tell someone who called 911 that they shouldn't have called, because they don't know what you know. They don't know what they don't know. Now, what to do is, the spectrum of what to do is basically limitless. You could certainly do a criminal referral. You could have a community liaison officer between calls go out there and talk to them and enlighten them, not on a 911 summoned basis. I know a lot of agencies are using social media to share reasons for and for not calling 911. There's a number of things that you can do. Pick anyone that works, try them. If they don't work, try something else, but don't do it on the call.
What is the best way for EMS providers to establish capacity? For example, you got an intoxicated individual, but they are lucid and able to answer questions.
First of all, you don't know what an intoxicated individual legally, I'm using air quotes because we all know what one is, but legally, unless you're trained as a DRE, you don't know what an intoxicated person is anyway. So remember to use lawyer special protective words like suspected or alleged or possible. So with that out of the way, with that little caveat out of the way, that happens all the time. And my answer would be employ what's called the reasonable person test. Would a reasonably prudent, sober person with the same level of education in the same area under similar circumstances make the same decision? And the easiest example is this. It's 1 o'clock in the morning, you call to the dive bar where this elderly gentleman has come out. The witnesses are there. They say he's been there since 6 p.m., pounding scotches all night. Trips over a parking lot thing and sustains a blunt force head trauma, as a result of which he sustains a full thickness scalp laceration. You can see the skull in the laceration caused by the blunt force trauma. He is alert and/or stinks like alcohol, eyes are bloody, ready, bloodshot, whatever. And he's hammered, but he answers all your questions clearly. There's no delay in the answer to questions. No reason whatsoever to question his orientation at all. But he says he doesn't want to go to the hospital. I would, and this is just us talking now, this is not legal advice, this is just us talking, because I'm not your lawyer, would a reasonably prudent, sober person who knew they had a full thickness scalp laceration from blunt force head trauma, would a reasonably prudent, sober person refuse care? And I believe they would not. And I believe you could argue lack of capacity. Now, what you're thinking is, whoa, that's a moving target. It is. It's all a moving target. Okay. So it goes back to a core decision. Is it a clinical, objective, righteous, and explicable decision to take this guy against his will? If it is, then do it. We'll talk about that in a second. Don't worry about kidnapping or assault or battery. People can allege that. I'm not familiar with a single case of kidnapping by an EMS provider where the EMS provider acted reasonably. I'm not aware of a single case where they were subject to any sort of liability or culpability. Okay. Now, as for taking them against their will, good luck with that. I have no idea. Every jurisdiction is different. In more and more these days, especially in more urban settings, police departments are not going to have any part of that. So how you do it, I haven't the faintest clue. But if the question is, how do you determine capacity? It's the reasonable person.
I like it. Here's another one. If called by law enforcement to assist with a possible suicidal patient, you arrive on scene and patient is in full denial with no evidence of suicidal ideations. They're awake and alert and oriented. Can they sign a refusal? And then the next part is, if you do get called back later for same patient with a possible dead on arrival, are you at risk of legal action? So kind of a two-part question. So law enforcement calls, says suicidal patient, no evidence, can they sign a refusal? And then what if they sign the refusal, you go back, and now they have done what law enforcement said they were threatening? Are you at risk?
The answer to the first question is sure, right? If they're alert and oriented and there's no evidence, either direct or circumstantial evidence, that they truly intended to carry out the threat of suicide, then no, I don't think we don't get to take them, right? Boyfriend says girlfriend took a handful of Tylenol. There's no evidence of Tylenol. He shows you an empty bottle. She says, I didn't take it. You might caution her, well, if you did, here's what you could face. Here's what you're going to be up against if you don't get treated now. But without direct or circumstantial evidence, I don't think you can. Now, if your conclusion was reached after all reasonable efforts to make that determination were done, then I don't believe ultimately that you can be held liable. However, there are so many variables and there are so many other things that can go wrong and other claims people can make that it is going to be very murky and dangerous waters. So again, core decision. If clinically, objectively, righteously, and explicably, you have no reason to believe that it's true, then I think you have a duty to act on that belief of it not being true. So the follow-up question would be, well, what is the threat? Oh, his aunt called from Alaska saying that she was on the phone with him or saw a Facebook post or something. You know what I mean? You got to do some detective work.
Does a patient have a legal right to choose what hospital they are transported to? What if a protocol dictates otherwise? This question, I think, stems from your agency says if you think they're having a heart attack, they have to go to hospital A. You're on scene with this patient. This patient doesn't want to go to hospital A. They want to go to hospital B. So does the patient have the right to determine what hospital they're being transported to?
Answer, yes and no. The patient always has the choice of where they want to be taken, but that choice has to be reasonable in under the circumstances, right? So if you're in a city center and there's a hospital 3 blocks away, but the patient wants to go to the hospital 7 towns over, that's not going to likely generally be deemed reasonable. If the patient is in full STEMI and the hospital down the street is a STEMI center and the hospital they want to go to is not, then no, they don't get to make that decision. And it's one of those situations where it's easier to get forgiveness than permission, right? And that would be my opinion of that. However, I would also make base hospital hey, base hospital, since it's your medical control that we are operating under, here's the situation. What do you think about it? I'm all about passing the buck. I'm a youngest sibling. Youngest siblings are all about blaming somebody else. So I would do that if you have that option available to you.
Perfect. This next one's going to be easy, but off shift, I needle decompress an obvious pneumothorax and save the person's life. Can I lose my job or be sued?
All 3 things: lose your job, be sued, and lose your license. However, in this world we live in, sometimes we have to gamble and decide whether we are willing to take those consequences. I had a long story short, I had a case where a provider performed an RSI in a jurisdiction where that was not allowed by protocol. And she had done it. She'd been trained twice. She'd done it 6 times in her career. The patient was a friend of everybody on scene. It was an off-duty fire captain. And she participated with it was a mutual aid crew because half the state was on fire. So the crew that was backfilling the station where she was assigned was from the very city in another state where she worked. They had all the equipment, and under the mutual aid compact, they're allowed to do it. She assisted by pushing 2 of the drugs where, she wasn't allowed to push. Saved the guy's life, makes a full recovery, and the state sought to revoke her license. We won that at trial because she owned it and it was reasonable for her to do. So the moral of the story, the lesson to take is, whatever you decide to do, if there are consequences, you got to weigh them out. And if you're going to risk saving someone's life versus losing your job, make that choice. But the short answer is, yeah, absolutely, you can lose everything.
Any advice for documenting involuntary transports? So this would be like, law enforcement says they have to go, or you were talking, I don't care what you called it, but 72-hour psych holds. What is your advice for documenting those?
It's the same, everything I just talked about, right? Document on the patio. Make sure that every T is crossed and I is dotted.
Should any EMS provider ever talk a patient out of transport?
No, first of all, no, right? Think of it this way. We don't know what we don't know, right? And if the patient wants to go, even though you know for sure the patient doesn't need to go, who are you to tell them, I'm not taking you. I can't. You won't. I will. You can't refuse that, right? If you try to talk them out of it and you are successful and there's an adverse consequence, let's say that they crash the car and die in a car crash on the way to the hospital. Let's say they don't get to the hospital in time and they die. Let's say any number of things happens. The question is going to be, well, they wanted to go? Yes. And you didn't take them? No. You talked them out of going? Yes. Hand me over your cert, hand me over your uniform, hand me over your badge. You don't work here anymore. Go talk to those guys in uniforms over there. That's what's going to happen. Okay. And I get, like, so many stories I had a client who attempted to talk a patient out of going to the hospital. He was not successful. He ended up transporting to the hospital. Somebody reported him to the state, and the state, we went almost all the way to trial over that because they wanted to revoke his license over that.
So here's the last one in the queue, and then we'll just kind of move on with the ending slides, and everybody pops in. We can. I know it's right at a 2-hour mark, but DEI education requirements in EMS. Can a state mandate this as part of the recertification requirements?
All right. Yeah, a state can require whatever the state wants to require because the state is the government. They're the ones who make the rules. If they do it today, they're going to lose all their federal funding. So good luck with that. A state can, as long as their whatever requirements they have are constitutional and don't break any laws, yeah, I mean, they can, that's what they're there for.
Those of you watching it on EMS Connect, there is a required CAPC survey. Let us know what you think. There is a post-test. This post-test, man, David's presentation was awesome. It was hard to write a post-test related to that. So most of my questions that I came up with are just generic medical, legal topics. So test is pretty straightforward, pretty easy. I would say it's kind of a softball of a question or of a test. So take a look at that. Enjoy your cert. Everyone have a great day. It was a pleasure, and we'll see you next time.